go ahead and start Bar Talk, and so we can get our introduction of the acting Chief Justice that's currently on with us. Good morning, everyone. It's September 21st, and we had some unfortunate news over the weekend about us losing Justice Ruth Bader Ginsburg, and there's actually a link on the slide for today's Bar Talk for you to read some more about what Governor Mills said about her. I guess Governor Mills, when she was the Attorney General, had a chance to meet her. One of the things we wanted to do was just give you've got a couple links to updates from the federal court, indicating they've had a change in essentially the operations of how you enter their courthouse. I would suggest you just review it and before you go in, so that you're prepared about food, drink, and your electronic devices, and what questions you're going to be asked. And then there was also an update through a general order on court operations. And from what I gleaned on my read of it, civil and criminal jury proceedings are going to be moved to January and later. They did have some that it looked like they were scheduled for October, November, December. All of those are continued, it looked like, automatically by the order. And then what happens next, who knows? So with regard to, looks like we have some court closings. Maybe we could even ask the acting chief judge if he has an idea about why they have those in Rumford and Calais. And then we do have some business side updates we just want to do, and I'm thinking we'll do those after Chief Mead, because we want to make sure we have enough time for any questions and information that we have to share today. So thank you everyone for joining us, and Chief Mead, thank you for joining us again for Bar Talk. And I know that we're getting very close to our electronic filing rollout in District 5, and we're hoping that we might hear more about that, and possibly how the Tyler Technologies trainings are going. And Chief, floor is yours.
Thank you, Thad, and thank you to the MSBA for making this this platform, this forum available to the judicial branch. We don't have a broadcast facility. We have a website where we try and keep folks updated, but it's great to have this opportunity, and we thank you for that. Angela sent me some questions, some areas of interest that I guess the MSBA wanted me to address here today, and I will. I've collected some information and address those, but before I jump into those, just want to make a couple of sort of overarching big picture observations. The COVID-19 crisis for me started in mid to late March, so we've been into it, at least in that degree, for like 6 months now. And the good news out of that is that we have been able to keep the courts open. We have opened incrementally, moving along, and I'm pleased about that. The bad news is that the challenges are just immense. Moving forward with safety in mind, we, as I've said many times, are having to reinvent how we do what it is we do. And I'm getting a whole new sense of respect for the main rules of court that have evolved over decades. They've been tweaked, they've been adjusted, and they're working really quite well. We also, over the years, have had to make procedures and processes for efficiency purposes. As you know, as I hope you know, here in Maine, we have fewer judges per capita population than just about any other state. We may be at the absolute bottom, but if not, we're down towards the bottom. If you look at cases with similar states with similar demographics, they have twice as many, sometimes 3 times as many judges. So with so few of us serving so many of you, we've had to create processes to resolve cases, mediation, and of course the large docket call types of cases, where we bring in large numbers, expose them all to trial. Obviously, you can't possibly have trials in every one of those cases, but the prospect of having an immediate trial often is the catalyst that resolves the case. We've lost all those opportunities. We've had to reinvent what we're doing. We've created new processes, new procedures, and as always, the devil is in the details. We come up with what we believe is a thoughtful, complete, comprehensive approach to something, put it in place, and of course, questions arise, clarifications are requested, and it is clearly a process, and it is a process that takes really all of our time. I have to give credit to the members of the judicial branch, particularly the trial court chiefs and the regional judges. They've been on the front lines through all of this, and I cannot say enough about the dedication, the effort, and the time they have put into to try and address all these devils in the details. But we are moving forward. It looks like this is going to be with us for a while. We're going to do the best we can. I know that probably everyone has a particular point, a pet concern, that why can't we address this concern? I can assure you that we are probably aware of the concern and are moving forward as best we can. We will address changes and adjustments that need to be made underway. We're using the pandemic management order format because it is quick, it is easy to adjust, and we've modified them along the way. That is our intent, to go forward and get us as close as we can to normal. I'm not sure we can ever completely get to normal, at least the way that life was before the pandemic hit. But rest assured, it's occupying all of our waking hours and frankly, some of my sleeping hours also. We're trying to move forward, and I know you're doing the same. I want to thank the members of the bar. You've been understanding through all of this, despite the fact you have your own hardships. So thank you. Thank you for that. So I have some questions, some areas that the bar is interested in. I will try and address those. The first is, we would like you to touch base on phase 4 planning to phase 5. As you recall, the pandemic management plan involves moving forward from phase 4 to phase 5, which envisions, at least opens the door to jury trials. We didn't know whether we would be ready for jury trials in September. Clearly, we were not. We have a jury management group that is working very, very hard to come up with procedures and processes for conducting jury trials with the restrictions we have based upon the health concerns. September arrived, we were not there. The decision was made to conduct 2 pilot jury trial sites, one in Bangor, one in Augusta, because each of those locations has a large multi-purpose room that lent itself to jury selection. We moved forward with that, but the problem was we would not get the results from those pilot trials in time to plan for jury trials in October. So we pushed the dates out, understanding that hopefully once we have these trials undertaken, we have the lessons learned, and we have a template from our jury management group, a cookbook on how to conduct jury trials during the pandemic era. That is why it was rolled out to, phase 5 is rolled out to November 9th. So the pilot programs, as I said, are taking place in Bangor and Augusta. Our group, the working group, surveyed these locations, they did the measurements, they researched public health guidance, they developed multifaceted proposals for safety, resuming jury trials in the main courts. They actually had a walkthrough conducted by CDC representatives to look at how they're doing everything. And I'm happy to say that they gave us excellent grades on what we've done. We tried 2 types of jury trials for this process. One would be a murder trial to take place in Bangor. Jury selection is taking place today. They're hoping to get the trial underway later this week. In Augusta, they decided not to take a large case that would occupy the docket like that, but rather simply address the pending docket. And that being the case, many cases were exposed to trials. As I said, that is the catalyst that foments settlement. And out of that, they came out with 2 OUI jury trials. The first of which was set to go. A witness in the trial was exposed to coronavirus and therefore had to quarantine. Thought was made to have that witness testify by remote connection. The defense objected vociferously to that, and the presiding justice made the decision to continue the case. So that matter is continued. There is a second jury trial expected to commence, I believe, on the 24th. So the configurations within the courtroom, if you're not aware of this, counsel tables have been turned so that the jury has great sight lines, because the jury members will be placed in the public gallery viewing area, the public seating area. Hand sanitizers available everywhere. We have set up plexiglass panels, and we are using headsets to amplify the sound so the jury can make sure that they hear everything that is taking place. The participants, the players, the lawyers, the clerks conducted a walkthrough, sort of a mock trial to make sure that entrance routes, exit routes, and lines of sight are all going to be adequate. So we're crossing our fingers. We'll decide what lessons are learned. The jury working group will submit its report, its recommendation, the cookbook for going forward. And I am optimistic that we will return to some form of jury trials throughout the state. Stay tuned for further developments. How is the Zoom transformation working? As you know, we tried to start remote proceedings using Google Meet and found that it wasn't quite up to the task. We shifted over to the Zoom platform. Turns out this is a large undertaking. My vision, my plan is to have every clerk, every judge competent and comfortable and confident in hosting Zoom sessions moving forward. So it's a rollout process. We have to license them, which turned out to have its own complexities. But we have a team, a technology team, that is taking care of the training, the rollout, and moving forward with it. I said before, the devil's in the details. We are addressing issues of confidentiality. We are addressing issues of interfacing with our existing systems. We have an existing video conferencing system called Polycom, which is not well loved. It was a state of the art, 2-3 decades ago, but it doesn't necessarily play nice with Zoom, so we're working on that. Issues of how to create the record, how different cases are managed, marking exhibits, staffing requirement, all of these things. So my vision was, let's get it out, let's get it started, but now we need processes, we need procedures. We are working on that. It is going well, and I'm optimistic that it will continue to go well. One of the side issues that I can talk about now or later is PMO 7, as you undoubtedly have reviewed, announces that video remote is the go-to presumed format for court proceedings, most court proceedings, unless it simply can't be done. We had issued a directive that we would not be using hybrid proceedings, which is some people are in the courtroom and some people will be testifying remotely, except in exceptional circumstances, which might have been that jury trial that was not proceeding. We've since received some folks who've suggested that hybrid should be the presumed format for certain folks, people who are at risk for COVID. Makes sense? Of course it makes sense. The reason why we presented the directive not to have hybrids is because Polycom would be the go-to format there. If a judge were to approve the hybrid format, the next question is, okay, how do we do that? If the Polycom is not available or you have to go with Zoom, that entails technical support. We do not have a huge technical support staff. Right now, most of them are dedicated to getting the case management system up, working on the Zoom rollout. And if 6 court locations all decided to proceed with a hybrid proceeding, they need tech support, and we simply can't provide it. So we are grappling with that. There is a valid reason why people should be able to testify remotely in a hybrid setting. We are lacking the resources. We did make a CARES request for a major infusion of cash to equip each courtroom with a turnkey system that will allow the judge to simply set it up, go, good to go. We haven't received a favorable response yet, and I am not optimistic that we're going to get them, but I just offer that out there as an example of what we're trying to do and the challenges that we're facing. I should add that the Violations Bureau is one of the settings where we are hoping to really leverage the remote proceedings. The Violations Bureau has a backlog of almost 7,000 cases. Let me repeat that for emphasis. A backlog of 7,000 cases. We can't address that without leveraging the Zoom platform, and they are going to be piloting that for contested traffic hearings later this month. To further create efficiencies there, the Violations Bureau will be held cases will be held in 1 or 2 designated locations and managed by a specialized Violations Bureau team. Another example of how we're reinventing what we do, how we do it. Please address the status of the electronic filing rules. As you know, I hope you know, that we have promulgated the main rules of electronic court systems, RECs. We call it the RECs rules, which is somewhat redundant, but that's the shorthand for it. They are available on the website. We've had a request for training. We're going to be doing a presentation open to all on September 30th at 12:30 to 2:30. Information on that training session and a link is on our website. This is intended to be really sort of a high-level review of the structure of the rules. We'll look at some of the most critical features directly relevant to the cases that are going to be going live in Bangor on October 5th. Live, I should say, in Bangor, the BCD, and the Violations Bureau. For example, we're not going to be covering the criminal types at that time. Later training will be offered on the rules on those case types. But I want to emphasize this. The training on the RECs rules is not a substitute for your own thorough review of the rules. Obviously, you want to have your staff folks look at them, become very familiar with them, but you must read them. These are new ways of doing business, and really nothing substitutes for a cover-to-cover reading of those new rules. We're asking for your feedback. We're building this from the ground up. We're building it from scratch. Clearly, there will be needs for tweaks, adjustments, and clarifications. We do welcome your feedback, and we invite that. We have created a web email mailing address at ecourtshelp@courts.maine.gov. It's on our website. Any questions you have about our CMS e-filing, suggestions, drop us a note. That email address will be monitored in real time, and we are anticipating that you are going to be making suggestions and requesting clarifications. There will be ongoing training for filings in Bangor. There will be free online kind of nuts and bolts training sessions. For information on how to register for those and how to use eFile Maine, check our website. I believe the Board of Overseers sent out a blast with those training dates information. You don't have to attend all of them. It's being repeated so you can attend at your convenience. So check our website, check your mail from the Board of Overseers about particular training sessions regarding the Bangor process. As I said, there will be a RECs presentation on September 30th at 12:30. What steps is the judicial branch taking to adjust to e-filing? We have training for all of our users here within the court system. We have intensive internal training for all court personnel and the judges who will be using e-filing. We have a great project management team. we are going to be ready to go on October 5th. And as I said previously, regarding the business court, the BCD will be part of the rollout. So if you are practicing in the BCD or anticipate having cases there, you want to be taking advantage of the training opportunities that are being offered. Why hasn't a Superior Court judge been assigned to Androscoggin County? Actually, there was a justice assigned to Androscoggin County on a full-time basis. Justice Stanfill is there. She'll be there for the foreseeable future. And I point out that judicial assignments for specific courts and dockets are driven by the data, by the case filing trends, particular emergent needs, so they change over time. But this is not arbitrary or based on seniority or something. It is based on the need. But Justice Stanfill is there. You can check in with her if you want to make sure, but she is on the job. Footnote to that is, at the present time, we have 4 district court vacancies, 1 Superior Court vacancy, and of course 1 law court vacancy. And as you know, vacancies are nominated by the governor and confirmed by the legislature, so it's impossible to say exactly when they will be filled. One optimistic note, we believe that in the near future, we are going to be able to leverage active retired judges. So that will help pick up some of the slack here. Stay tuned for that. Developments are occurring as we speak.
And Justice Mead, I was going to ask you about that too. I'm glad you addressed it. So my understanding is that we haven't been seeing a whole lot of active retired judges right now because of funding. Is that correct?
That's correct. We believe that a workaround is in the works, and we are working on it, and I'm very optimistic. So I believe that you will be seeing ARJs at some point in the future, and I'll give you further updates as developments occur. Traditionally, we have been able to file proposed orders, including proposed child support orders and child support worksheets and family law trials via email at proposedorders@courts.maine.gov. To be clear on that, the revised PMO3 states that effective the September 8th, attorneys and parties may still submit proposed orders in the Word format at the same email address. It's available only to submit editable versions of proposed orders, and it's not for filing other types of filings like affidavits or guardian ad litem reports and so on. It's proposed orders. I think what may have happened here was that some folks were filing documents that were not editable, and it's critical that we be able to edit those. So that would be a Word doc. I think some of you who are particularly astute at using Acrobat products can create editable PDFs, but I think the standard going forward would be an editable Word document. And I think that is what I had for questions here. I don't know if you had other questions or wish me to address other points that are bubbling out there. We're happy to do so if we can.
Well, one of the things I wanted to thank you, Chief. One of the things I want to let people know is please, any questions you might have, put them into chat, and the chat room is monitored by Angela, and she'll be able to give us the questions or share the questions with the group.
I have a question.
Oh, go ahead, Angela.
So there is still concern about the safety of the in-person lawyer of the day because the facilities do not allow for private consultation with the clients except in small, poorly ventilated conference rooms. Apparently there was an attorney that tested positive for COVID, and her doctor believes that she may have been exposed when she was lawyer of the day. So is that something you can speak to, Chief?
We literally just talked about that situation with the chiefs this morning. We're involving John Pelletier, of course, who runs the MCLS project. Also involving, we have a COVID team within the JB that specializes in the precautionary measures we're taking. So to answer, I can't answer that question right now, but it has bubbled to the forefront of the issues that we are dealing with. So you may see something down the road. Our mission, I think, as I've said so many times, there's two tiers to it. There are two horns to this dilemma. Safety is at the forefront, and providing access to justice is at the forefront, but we will not sacrifice anyone's health for doing what they need to do. And again, we are so grateful for the work that the lawyers of the day do. That has been one of those innovations that has really, really moved things forward. And for us to be anything less than vigilant about the health and safety of the lawyer of the day, I think would be the wrong message. It is not. We will keep that right at the forefront. And as soon as something comes of that, we will probably make an announcement. It's a tough nut to crack, but I think we've got the issues out here, and we're moving forward. It's at the top of our agenda.
And Justice Mead, I wanted to ask, in light of maybe what I just let you know about what came out of the federal court regarding future jury trials, has the state court been thinking about whether or not we're still on schedule for, I think stage 5 is still slated for November 6th. Is that right?
Yes, that is very contingent. And once again, health and safety is our primary concern there. And just regarding the jury trials, there's a 3-tiered process. We send out a questionnaire about if anyone has health concerns or limitations, and anyone with a COVID concern, we absolutely accept that at face value. We send out a secondary one regarding potential concerns about the system or the cases that are coming up before we even go to jury selection. We had CDC representatives come in and look at the courtroom in Augusta, which is a mirror image of what is happening in Bangor, look at the jury selection areas, and they have blessed that. They said we've gone above and beyond the requirements there. So to answer your question, will there be jury trials on November 9th or shortly thereafter? We have to wait and see this experiment, how it goes down. Is it all feasible? Do we have a cookbook? Do we have a template for conducting safe jury trials in other locations? I'm champing at the bit, as everyone else is, to get the jury working group's report. Only when we get the report will I be able to answer your question definitively. The report may say our precautions have been deemed adequate. The trials went down safely. There were no breaches of safety requirements. And we believe that these locations, and they may list 4 or 5 locations, also are up to par, and they're green lighted. So once that green light comes out, the organizing people, the district attorneys, attorney generals, the clerks, and the judges can start planning, sending out questionnaires, and so on. Is there enough time to get that done, to have trials after November 9th? Possibly. That's still a big question mark. So I can't be any more detailed about that, except to say when we get that report, that's the next big step forward.
Well, thank you, Chief. I was also, I think there were some other subject matter areas in stage 5 too. For instance, I think small claims cases, we haven't heard a whole lot of.
Yeah, I've been calling those the verboten cases. As you know, we opened up, these are typically large docket cases where we get a lot of people into the courtroom. We can't possibly do all those hearings in a given morning or afternoon, but most of them settle, they resolve. We opened the door to evictions. Evictions really was to be the litmus test to see whether we can do them using alternative procedures. And then, as you know, we received the order from the Department of Health and Human Services, the federal DHHS, which interjected some question marks to that process. So I was hoping to have an answer for everyone on the verboten case types, the remaining few, based upon our success with the eviction cases. But as I keep saying, the devil's in the details. We need to understand fully the effect that the federal DHHS proclamation has on those cases. So regretfully, still a question mark on when those cases roll forward.
And Chief, thank you. I think Angela actually had another question or two there. We have about a minute left. I wanted to see what we can roll into. Thank you.
I do have a couple more. We'll see if we can get through them. Is there a special protocol for attorneys to notify a court if they experience COVID-type symptoms the day that they are supposed to appear in person at a courthouse and would not be able to pass screening at the courthouse doors?
Great question. I don't think there is. Our screening process, as you know, takes place at the door. So I suppose if an attorney knows ahead of time, you know, someone in my household has COVID, I'm clearly exposed. When I get to the door, I'm not going to be able to come through, because I'll answer that question, yes. Hopefully, attorneys would be responsible and call up the court and say, oh, by the way, I'm not going to be able to pass the screening for my trial next Thursday. Perhaps we should create a protocol for doing that. We'll look into that. Thank you. Good question.
And also when you're looking at that, Chief, you know, sometimes it might be the day of, they may not know. So that was part of the concern too.
Of course.
Then the other question, the elimination of emailing pleadings in criminal matters creates some logistical issues, including necessitating visiting courthouses in person in order to ensure that they are timely filed. For many motions, they are delivered in person, and in York, Cumberland, Kennebec counties, they're doing so on a weekly basis. It's not really a question so much as it seems to be some logistical concerns there.
And to me, the concern is that there may not be uniform processes across the state. I would just ask folks who have filing deadlines to try and anticipate that and put it in the regular mail, assuming the post office is still delivering as we assume it is now. And there will be inevitable situations where something clearly pushes up against the last minute and requires a delivery, and we can't avoid that. And it's hard to create uniform processes across the state because it is so ad hoc. I will take it up with the chiefs once again, but I think to the extent you can anticipate deadlines, get them in ahead of time. To the extent you can't, look to the local processes for getting those in, and we will visit it again.
And Angela, we are kind of out of time. Was there any other important ones that were pending before we end?
Not for Justice Mead. I just wanted I've had a couple people ask about these links that are on the slide, and these orders are available on the MSBA website if anybody's looking for them.
And I would say, just once again, any person who has questions that really relate to electronic stuff, or you want to get it to us, there's that eCourts help email address. As I said, that's going to be staffed in real time. And questions like these, if they land there, will get referred to us. And the chiefs and I will add it to our burgeoning agendas. When we meet, we talk about lots and lots of stuff. But these are good questions. Probably eCourts help is one way to get them to a conduit that will shuffle them to us.
And Acting Chief Justice Mead, thank you very much for joining us today. And we appreciate your time. And we've all learned something here, and we hope that you'll be able to join us again with important updates that you want to share with us. Thank you.
And thank you, Thad, and the MSBA. Thank the entire profession for what you're doing, and keep in touch. We'll get through this together.
See ya.
Thanks, Justice Mead.
Thank you.